Welcome to Recogs, the inventory success podcast where we discuss how the top operators source, manufacture, finance, and sell their inventory in order to create successful businesses. I'm your host, Mike Gelb. I'm the community manager here at Manufactured. We are the inventory success platform for consumer and B2B companies. So this is one of our recasts of a webinar we did about Subchapter 5. So previously, we released the first part of this webinar. I was talking to Gregory Jones, who is a trustee on over 30 Subchapter 5 cases. And this time, we're going to hear from the debtor's lawyer's perspective. So if you haven't checked out that first episode with Gregory Jones, I think that will be helpful in terms of understanding what a trustee does and really understanding and laying fundamentally what Subchapter 5 is and where it can be a very, very helpful and useful mechanism for SMBs when it comes to bankruptcy. This is from the debtor's lawyer's perspective. We're going to be chatting with Joseph C. Barcalona II. He has a lot of experience representing debtors in Subchapter 5 cases. Joseph is a partner in Pashman, Stein, Walder, and Hayden PC's Bankruptcy, Restructuring, and Creditors' Rights Practice Group. And towards the end of the session, you'll want to hear again from Jeff Sands, who is a founding partner of Dorset Partners and specializes in turnarounds, capital, debt restructuring, M&A. We've talked to several companies that have gone through a Subchapter 5, and it is quite interesting how once going through this process in order to restructure their debt, how they're now thriving from it. So to share his thoughts and takeaways from the debtor's lawyer's perspective and who the debtor is, it would be the brand that would actually file the Chapter 5 bankruptcy. So representing that company, that would be that's the lawyer representing that brand. So without further ado, here's a recast of my conversation with Joseph C. Barcalona II. So now we'll hear from the debtor's lawyer's perspective. Welcome, Joseph. Joseph, how are you doing?
Good. How you doing, Mike?
Good. Thanks again so much for your time. Really appreciate it. So talk to me first of all at maybe the beginning of the journey with a company when you first engage. When do you first get involved with a company or debtor that might be considering a Subchapter 5?
Absolutely. And let me go back first to something that Greg had mentioned and looking at what the Sub V code actually is. When I started practicing, obviously Sub V was not around at all. It was ingrained in my brain that Chapter 11 is a creditor's code. I would argue very forcefully that Sub V is more of a debtor-friendly code with the removal of the absolute priority rule, the removal of having an impaired accepting class. If you are a creditor and you are aware that a Sub V is coming, you better watch out. It is a very dangerous tool against your rights. And unless you are willing to put more good money into bad to fight that case, you are most likely going to come out on the short end of the stick at the end of the day. And while, the Subchapter V trustee may be a sounding board and is there, the code really says that its job is not as a fiduciary for creditors at all. They're supposed to get to a consensual plan at the end of the day. It doesn't give them investigation rights as a committee or any other type of powers that go beyond just getting to a consensual plan. So I see all of the Sub V trustees that I have worked with and currently work with as friends and partners, and there's more that act like Greg does as a committee advocate, but that is not their role. They are not a fiduciary. They are supposed to be a middleman between the debtor and its creditors to get to a consensual plan so that mom and pop businesses, which is what the statute was created to protect, can continue to flow. If that wasn't the basis for doing so, why would you allow equity to continue fully reinstated while general unsecured creditors are getting blown out of the water? So I want to level set there by saying Sub V is clearly a debtor-friendly code in the first instance. So every conversation I have with a company First, we have to figure out what situation they are in, period. Do they want to continue operating? Could they continue operating as a going concern? Only if they are going to reorganize would Sub V be on the table, because at the end of the day, it is still way more expensive than all the other type of restructuring options that are on the table. An assignment for the benefit of creditors, a Chapter 7 liquidation, an Article 9 foreclosure with your senior secured debt. All of those are more cost-efficient options, mostly on the liquidation side. But the only way to fully reorganize and keep your equity too is through the Sub V process. So I start the conversation, what's your cash on hand? What are your major debts? And we figure out an actual structure and strategy of what is best for this company, because all management and directors, I primarily practice in Delaware. I have some cases in New Jersey. I was out in Hawaii, but fiduciary duties is a known concept, right? In corporate law, prior to Chapter 11, you should only look out for shareholder interest. That's what the business judgment rule is. You're trying to maximize value for shareholders. Everybody knows that. When you breach solvency or insolvency, Delaware law at least expands those fiduciary duties to think about both equity and creditors. Back in the day, it was much easier for that demarcation line upon Chapter 11 to say, all right, no more shareholders. Now we can think about just creditors. How do we maximize their value? We're going to bring in the biggest pot of cash. Doesn't matter if it's liquidation, whatever, we got to pay them off. But what has Sub V done? It's now brought equity back into the conversation as a stakeholder that all of these fiduciaries really have to start thinking and caring about, because they are being very much impacted through this plan. And the majority of cases that I get, I'm hearing from sponsors, from people that have their company. They're usually the founders still. They're not the CFOs that have brought in after the fact, but they are current equity. And they're trying to figure out a way out where they can still keep their company. And that's what Sub V can do. That is an incredibly powerful tool. That was a powerful statement by Congress to allow small businesses to do that. And although we're at the $3 million limit, I agree with Greg, we're going to get to the 7.5 at some point. It really is based on whether one or two senators understand this is not just a COVID era bill. Once they get past that, they will see that, okay, we have to extend it out again so that we can reach the 7.5 threshold, and things will go back to normal, as you will. But for right now, it's at the $3 million mark. And that also guides the conversation, at least right now. Until they change the statute back, if they have $4 million, well, guys, you're not going to afford a regular Chapter 11. You're going to have to either liquidate or find some other means. So that usually jumpstarts the conversation. And I said, I wish you spoke to me on June 20th. We wouldn't be here for that.
I know. I hear you. And what Joseph's referring to, by the way, is the cap. And correct me if I'm wrong, Joseph. But the cap when Subchapter 5 was introduced was 2.5 million. Is that right? Back in 2020, and then it rose during COVID for relief. Primarily due to businesses that were impacted during COVID in 2021 to 7.5 million if you've debts. That's the cap, 7.5. And of course that stopped back in June 21st, is that right? This year. And now it's a little over 3 million, right? So that's so that cap has kind of gone back down to over 3. I would say, I guess thinking of when you talk to companies and you talk to them about what does it make sense to actually when you actually are reviewing their assets, and maybe this is a similar question that I asked Gregory, but when you are reviewing their assets and seeing if they're if they actually do have valuable assets versus not valuable assets, do you also guide or give recommendations to companies when it comes to when a Subchapter 5 might make sense to actually stay in business and actually want to recap versus actually going out and pursuing a Chapter 11 or ceasing to exist full liquidation of the company?
Absolutely, because what we're seeing, what I'm seeing a lot, are the companies that have the free liquidity and free money of the 2021, 2022, the founders right, that started these direct-to-consumer and internet companies that just had free money coming in. So they show me projections where they have 7 million of expenses and they make 25K a month. They said, is this even worth it? Like, why do you keep going with it? They're like, oh, I know, trust me, the brand has value. Okay, show me. So even going back to regular Chapter 11, you don't want to go in unless you have a plan for exit. So when I speak to these founders and whoever brings the case to me, I ask first, okay, do you have a way out? Have you been talking to a stalking horse buyer? Have you been talking to your senior secured debt holders? Do they want a credit bid? Are they going to fund this process? Where are you? Is this truly a free fall situation? Do you have other equity investors that are just waiting for a forgiveness of debt through a plan and potentially they'll put more money in? And there the conversation will go from there, because typically they found me or a debtor's lawyer by talking to one of those other players and saying, you really should start to think about these things. And you want to know where the nudge is coming from, because that entity is probably the one you're going to have to hold your hand with going into the restructuring. Now, that being said, I've filed a ton of free fall sub-Vs that are a disaster at first, but because of the tools of sub-V, you can put secured debt up that way and stretch them out. You can flatten guffs at the end of it. You can find ways through the code to do it. It's just more expense on the company, and all admin expenses, even at the effective date or whether we stretch them out in the plan, they have to be paid in full at the end of the day. So if this is an entity that has no secured debt on it, an admin claim post-effective date essentially is a secured claim. You have a super contract in that plan that you have to pay off all of that debt by the time you flip it or do something else. And you know, that guides the conversation with other investors and ways out, and just ways that the company could be successful. And you got to make that determination really early if you are the founder, given your fiduciary duties, of whether this thing should continue or whether we should just throw it into the trash bin.
Do you think as well for the, D2C brands, I'm just thinking about different types of debt as well, and it seems like there's a lot of now debt options, or ways to rather fund your company that is non-dilutive, that has kind of come to market. Really talking about, revenue-based financing options, for example, and different ways. What tends to be, is there a common type of loan a debtors might have that actually they struggle to pay back, or is there maybe a catalyst in terms of a debt product that has come out that was a catalyst for more companies filing Subchapter 5s?
Yeah, I would say one of the more frequent ones that we tend to use is through our 3PL, through our third-party logistics company, because under normal Uniform Commercial Code, Article 7 for warehouses, they have a secured claim up to the amount of collateral that they're holding. And they obviously have a lot of skin in the game to make sure they get back everything that they're owed as a warehouse based on fees, expenses, whatever. So we've actually been able to lend off of our warehouse to get more financing from them, and they will front the amount that they believe that they'll get and maybe enlarge their claim past the fees and expenses that they're owed, or in that way as a way to finance your case and to finance your business that otherwise would not be available. I mean, to go back to the limit, right? Remember what the limit is. It is non-CUD debt. CUD stands for contingent, unliquidated, and disputed.
From my perspective, bankruptcy is always your last option. Joe mentioned that, every other option's less expensive. And he mentioned the legal ones, in Article 9, assignment for the benefit of creditors, receiver, things like that. Ultimately, a bankruptcy is renegotiating all your contracts. And if you can't do it out of court, then you can go and say, hold on, you're being completely irrational. I'm going to go to a rational person and let them mediate this. And essentially that's the judge, trustee, and the bankruptcy court. In my practice, I use it as a cudgel, as a threat. listen, I can get this deal tomorrow in bankruptcy court. Why am I screwing around with you? Who's not listening and is, being irrational. And it's for me, it's a lever, to get people to negotiate and open up their mind. And often I say, I'm done talking to you. Go hire a bankruptcy lawyer, get them on the phone with me, and I can have a rational conversation, because you're not capable of that. You're just emotional about this debt. It's a number. People have been figuring this stuff out for 7,000 years. You're not the first guy to get wound up about it. We just need, an adult on your end to have this conversation. And we can force that through the courts, or you can just go bring in somebody who can help me help you. I filed my own bankruptcy in 2007. I just filed my first as a professional this year, which was a sub 5. And but I think that shows, how scores of businesses in the process, and I don't know, tens of thousands of creditors, all done out of court. So it, but maybe half of my success was that I had the threat of bankruptcy. Without the threat, then I would be far more toothless. And hopefully, Joe, you've got your audio back.
I do have my audio. Apologies, and it's through the computer, so of course once that goes out, that'll be bad. But to Jeff's point on that, when I'm speaking to companies, I really talk about the risk profile and what they can swallow. And when I say the risk profile, is how confident are you that your vendor is not going to sue you out of court, right? If you think Sam, Sally, et cetera, are all going to file lawsuits and collection suits against you, and you're going to be paying a million different ways out, then bankruptcy is that unified forum that stops all the noise, directs it in, and allows you to get there. There's been a ton of cases that I've had and have now filed where for months we were in a workout scenario, just like what Jeff was saying. And a lot of our creditors called our bluff and said, fine, you're not going to pay me. You're going to play these games. I'm going to sue you in state court. And where the costs, where they had the PGs attached or something else that had other weapons to use against the debtor or their principals, that's when we felt compelled, all right, we have to file a case. And if you hit, the only way you can do it and keep your business is through sub V. Keep your business is assuming that this is the equity holder that is choosing to file and has the corporate governance there to allow it to say, let's go forward at sub B. Because I still stand by the fact, if you are an equity holder, the only restructuring law in the world that allows you to keep your business while also taking down creditors is sub V. That's it. Any other way is going to be the priority scale, and absolute priority will rule the day.
No, that's really well said. Can you talk a little bit, Joe, about what a reorganization plan could look like? Especially how much also, I understand that this is, very debtor friendly. If you can also expand in terms of maybe things that you can do within your reorganization plan that you wouldn't be able to do, for example, if it was just a normal Chapter 11.
Absolutely. So when I think about and when I advise my clients on how to initially think about it, and the majority of these cases, yet again, are small. They don't have a restructuring professional financial advisor like Jeff to help them figure this out. So you're talking to mom and pops or other types of individuals that run their own books, and you have to get bankruptcy concepts in their heads. And I said, okay, imagine your worst case scenario that each one of your creditors is going to vote to reject the plan. And in sub V, you don't need to have one accepting class. Every single one of your creditors can hate your plan. You can still get it confirmed. But imagine that they do that. What do you have to satisfy to make it fair and equitable, which is the terminology under the code, in order to be confirmed over their rejection? And for general unsecured creditors, it's very simple. They just have to commit their disposable income, which is a defined term and I'll talk about in a bit, for a 3 to 5 year period. And that's a discretionary choice and an offer by the debtor that they're going to make on day one when they have to file their plan of what their disposable income looks like for the next 3 to 5 years, and whatever remainder will be committed to creditors. But I want to assume that we're going to get votes to say no, and then still commit that. So the 3 to 5 year thing, we talked about this a little bit, and there is some law that's developing around this. And in the first instance, it is really the debtor's choice of what they can do. I have gotten 5 plans confirmed, in the last 2 years, none of which paid off general unsecured creditors in full within 3 years. And they were all 3-year plans. And the majority of those 5 were completely consensual, because we were still providing enough value to that creditor base that got them on board. And through a solicitation process where we're getting votes, we also know who's angry, who wants to talk. Utilizing Greg and other sub-B trustees, we will mediate those issues, figure out what they want. Maybe we can bump up those projections. But at the end of the day, what we know we have to present and put on our affirmative case in front of that court is a feasible plan that's going to work for the next 3 to 5 years. And within that plan, there may be some wiggle room. Disposable income is a very flexible concept, okay? It's basically saying everything that the debtor doesn't need to normally operate, like wages, advertising.
Oh, so sorry, Joseph. We lost you again.
Dead.
Oh,
There we
How is
go.
it?
You're back.
Yeah.
You're back. You're back.
And now it's through the computer, so I'm going to keep coming out. I'm just going to have a lot of people waiting and with bated breath on what I'm saying. Is it working now?
Yeah,
Yeah.
it's working now. Yeah.
Okay. So we have to present a feasible plan to the court in order for it to be confirmed, even over all creditor votes. Feasibility it's not a defined term in the code. It just basically means it's not going to lead to another reorganization. So I have to put on an affirmative case at the time of confirmation that the projections that my guys have put together are going to work for the next 3 years and won't drive us into a Chapter 7 or another Chapter 11 case. So it's really a healthy medium of figuring out, all right, what are the absolute expenses that you need to be able to supply over the next 3 to 5 years? What do your wages look like? What is your advertising costs? What are your COGS? What do you need to do to make sure you can continue to operate and bring in revenue? And then the remainder is that disposable income that you commit. So that can always be flexible, and we can talk about it with other creditors. If we have major objections to our plan, we can talk with them and try to figure out, okay, you're challenging this number, then we'll get a couple more bucks out of here and throw it down there. At the end of the day, though, because we don't need their vote to get a plan confirmed, I know what I have to prove to get there in front of the court for a confirmation. And the only consequence of that is that the debtor won't get its discharge until the end of the plan term. And that's another thing that you think about of when you're going 3 to 5 years. How long can you really tolerate until you can get your discharge and get, free and clear accounting, it's called, for you as a debtor? You want to make sure that all of that stuff is off your books definitively. And that's why we always start with a 3-year, and then it maybe expands as we have more discussions. And it's a different calculus if you're spreading out administrative costs. Those are debts that accrue during the course of the Chapter 11. It's a much different conversation as the case goes along. But because of the statute set up that it's a very fast case, these things move, within a 4-month period, you're basically out of bankruptcy from soup to nuts. So, and that's all part of this theme of helping out the small business and making sure that the debtor survives. Sorry, creditors, you want something, go give to a bigger business, because in the small business world, we're just going to steamroll you in sub-V.
What happens when that maybe a 3-year, of course you have a 3-year plan, it gets accepted, and so you're out of bankruptcy. let's say things don't go nearly according to plan in those 3 years, and the creditors don't get nearly the amount, even though they're not paid back in full, but they don't get the amount that the plan suggests that they would get. What then actually happens 3 years later?
Yeah. So, and this is a point that I think all of our sub-B trustees and the United States trustees, which is an entity we haven't talked about, but that's an arm of the Department of Justice. They're another watchdog over the debtor to make sure, even if there's no creditor involvement, both the UST and the sub-B trustee are there to comment. And in both instances, when I've dealt with them in all the different venues I've been in, they always make a point, and we add it voluntarily now, that there are default provisions in our plan. This is a super contract. To be very clear, a plan is a super contract among the debtors and all of its creditors. So if we default on our promises under our projections, they can come back in and say, hey, that guy didn't pay me what he was supposed to in Q3. And because of that, they can bring it before the court. A determination can be made whether it is time to liquidate at that point. Maybe we move to modify. But there is safeguards that we, at least now, voluntarily build into our plan, and others speak up to make sure that they're in there, that, you know, there are remedies for creditors to come in, and if we don't live up to those promises. Now, in the situation where it's reversed and things are much better for the debtor, those are much more interesting circumstances. I had a case, Lunia, that was Lunia company that was confirmed end of last year. Okay. And we got confirmed. It was 1191B, non-consensual confirmation because we didn't have creditors accepting our plan. That's fine. So it was going to be a 3-year plan where we were committing all payments to GUCS for the next 3 years. Unbeknownst to me and the company, another financing party came in post-confirmation and said, Lunia, we're going to loan you $2.5 million. And we said, this is great. We can move to modify our plan because now it will adjust payments to everybody. However, the case law shows and the code says that you just have to commit projected disposable income to creditors, not actual disposable income. So I was able to go back and say, my projection showed only 160K to creditors, to GUCS. We'll still make those projections, even if there's more cash available. And we got the court to confirm the plan as amended based on my old projections, even if we had $2.5 million worth of financing. The same priorities had to be satisfied. We still had to pay admins in full. We still had all the secured debt to pay. We had a DIP financing in that case, priority unsecured paid in full, all of that. But at the end of the day, the case law is very clear that only projected disposable income needs to be paid out to GUCS, not actual disposable income. So any upside for the debtor post-effective date, it goes to the company. It does not go to creditors. Wow. Thus, going back to my main theme, this is a debtor code. It is not for creditors. And there's amazing things that you can find if you're a small business that are embodied into the statute that you can benefit from greatly.
Wow, that's fascinating. I mean, I was gonna ask, once you actually get out of a Subchapter 5 and you're no longer bankrupt as a company, if you're able to even take financing again, and clearly you can. So that's also really quite fascinating in terms of being so debtor friendly. What trends do you foresee within Subchapter 5? I think you were alluding to it, that it's going to go back to 7.5. You think it's going to go back to 7.5, but what do you, I mean, also, I guess, what's today the case? Like, how is Subchapter 5 treated today? Because I know that we've gone down to that 3 million cap. Have you seen less cases than I'd imagine for Subchapter 5, or not really?
No. It's interesting you say that, Mike, because I really thought there was going to be a huge influx of cases right before the deadline. There wasn't, and I think it goes back, 2 years when this happened before, when it matured. They didn't extend it, and it took about 2 weeks at that time to backdate it. And it was the same thing, 7.5 down to 3, and then Congress got their act together and brought it back up to 7.5. It may take a little bit longer now, but I think we will get there. Hopefully they go to 10. I think 10 million would be more realistic for the middle to lower market. But it's very clear by the statistics, and the American Bankruptcy Institute has done phenomenal work here in studying sub-V cases. These cases are working far better than regular Chapter 11 and small business debtor Chapter 11s, which is another, ugly stepchild of Chapter 11 that nobody uses. These things are, 75% or more confirmation rate, which is astounding, right? And at the end of the day, even if general unsecured creditors may be getting 5 cents on the dollar, it's better than a liquidation where they get nothing. So you still have a business partner, a go-forward business partner through this reorganization. You get to keep jobs, you get to do all of that. Mom and pops keep their company. And at the same time, you're seeing these positive results hit our local economies, our global economies. It's a powerful tool that if Congress would just wake up and say how successful this has been, and believe me, there's a ton of lobbying done by the ABI to show them exactly this, they would see that finally a statute is proven to work so well. And of course, that's the one that they let go. That explains our government today in a nutshell, right? So that's where we are. And Jeff is raising his hand.
75% confirmation rate in sub 5. I don't remember what it is in a straight 11. It's low. What do you remember what the number is?
I mean, you got to talk like 50 or less. Because a lot of them, you have fast sale cases, right? You either have in regular size, you have a fast sale under 363 or a reorganization. And reorganizations now tend to be, through restructuring support agreements. So they're already pre-planned, everything's good. So you know which ones are going to confirm. You don't see free falls there because you just wouldn't even file an 11, you either liquidate or do something else. So when you get to the confirmation rate, it is still at a lower median because of the impaired voting class thing. You give so much leverage to an out of the money creditor just to win their vote. You got to make sure you get the numerosity and be able to do that. Yet again, that is not a consideration at all in sub V. It doesn't matter if you're owed $10 billion. If you're a general unsecured creditor, you can vote to reject my plan. I won't solicit votes on you.
And if I can ride on your point about the higher confirmation rate, as a spectator, what happens when the company goes under, the building and the parking lot go dark, everybody finds new jobs, and and the economy absorbs it, and it works, and the economy has to revitalize itself. But you take 100 employees, there's always 5 old folks who can't find new jobs. There's the owner's kids who didn't go to college, or they didn't go to private school, they went to community college. And it's generational impacts that can hit an entrepreneur. Our society goads people into taking entrepreneurial risk without understanding the downside. And the downside is more than just getting your ass kicked. It's your kids not going to college. It's your wife hating your guts. It's all these soft things that are so destructive to society, which is why society has been dealing with debt and debt forgiveness since the Old Testament. Moses had restructuring laws. And my perspective, having been through this the hard way, it's the most fundamental rule in our commercial law, and I think it's probably the most important to give the famous term in bankruptcy is the honest but unfortunate.
Yes.
You got to give the honest but unfortunate people a chance to get back up on their feet and continue to employ people and continue to cycle money through the economy, et cetera. And one trip through the Rust Belt, and we see what happens when we don't do that well.
100% agree.
Yeah, those are. I mean, that's extremely well said. Extremely well said. I think.
I'll also mention one other thing. We talked about, can you get financing coming out of bankruptcy? Clearly, the underwriting's tougher. A lot of people, like a bank will just say no because we have a rule. Anybody checks that box is persona non grata. But a private financier looks at it. So working capital is cash plus AR plus inventory minus AP. When you go through in court or out of court, just restructuring, you take all your AP and you convert it to long-term debt. Now your working capital just swung dramatically, and an ABL lender or a factor or somebody is much happier to step into that role because it frees up a lot of collateral coverage, and it really gives it gives the entrepreneur in the business a fresh footing, but it also gives the balance sheet a fresh footing, which new lenders find very attractive.
Do you think that, and I know I asked this question to Gregory, and Gregory, he hasn't said that he hasn't seen a change, but do you think that, let's say for example it goes to 10 million and up, and the cap gets upped into what you all perceive correct, right? Do you think that this will change how creditors underwrite when it comes to into small businesses, or not so much, just because this is a very small a in it this is actually quite, maybe a small section when it comes to what could go wrong, or the outcome of a business.
I definitely think it's going to have an impact, and you have such a small sample size of sub B because it only came about,
Right.
in the start of 2020, and right now you've had the fluctuations of everything, and no higher than 7.5. The market hasn't had time to react, but at some point they're going to be looking at these small credits and saying, what is my possibility of going into a sub B process where even if I'm secured, right? Another thing we haven't even talked about, I think, through either episode, is the fact that secured creditors too are harmed, or can be harmed in this process way more than a regular Chapter 11. All you need to do as a sub V debtor is, yet again, just commit. You know what they're owed, and they have an allowed secured claim up to the amount of the collateral. So in the case you talked about before, Mike, where there's no assets, they have a secured claim of 0, right? So all I have to do is pay that existed as of the petition date through my plan, and that is fair and equitable for a secured credit. So I absolutely think the market is going to start paying attention to this. I don't know how many times that debtors have taken that risk to go up against their secured creditor like that. I know we have pushed the envelope in some of our cases that I won't mention with our secured creditors, and we've got there with them saying, we can do this to you, we won't, let's strike a deal. Because at the end of the day, I too want to make sure it's a consensual plan. My goal, no matter what, is to make everyone happy through this process, the company as well as the creditors. I'm a fiduciary too. Under Section 327A, where I'm being retained by the estate, I'm a fiduciary for the estate. I have to get the best value for the estate, and that's everybody. Typically, that is, the majority instance is a reorganized entity paying less to most people. But it is also in the stance where I have my secured creditor. I know what they're owed. We got to find a way to pay them first, and maybe maximization is through a liquidation instead. So my job as debtors counsel is also to be a fiduciary to everybody else, to make sure everyone is comfortable under the lines of the code of what we can do in order for this company to reorganize. I take all of my discussions like that, with integrity, and to make sure that everyone is protected throughout the entire process. Notwithstanding some of my comments on this podcast, I do look out for everyone. That's part of my job. And that's what makes this so great. You can see the passion on my face. I love sub B. It needs to get back up to that level, because at 3 million, it's just not a workable statute for small businesses. It really isn't, because it's still too expensive of a process for an entity that would only have $3 million on the capital stack, right? So it's unworkable until they get it back up.
You might have answered this already, but why do you think why do you think that that there wasn't a rush for sub V cases, in leading up to the increase, the reduction in terms of the cap?
It's a really good question, Mike. I mean, I've thought about it a lot. I wonder, I mean, the economic situation hasn't really changed, and it's not as if I had 10 potential matters and it dropped down. I had the same amount of matters that I was talking to people, and we said, yeah, this is going on. It didn't, either people weren't really paying attention to it, which I think is number one, right? I mean, businesses, they still see bankruptcy as a stigma, and that's the last thing they want to think about. They do not think about it early enough for their survival, and they should. And they certainly weren't with respect to Congress. Like, they had no idea. So I think it's more of that. There wasn't, I mean, attorneys can't really solicit business. We can't go and say, hey, I see you're distressed. Do you know about June 21st? But, so I think it was just a lack of general knowledge within any particular industry and amongst founders and other business owners. They didn't know it. I've had, one call after the 21st. They're like, oh, shucks, if we got to you beforehand, it would have been fine. But most instances, they're still in the same paradigm. Can we even reorganize? And if so, what does that look like? And if not, let's find another restructuring alternative. Because there is still a great flux of where a company can go, depending on where their cash stands today and what their next step is.
Yeah, that makes a lot of sense, in terms of why there hasn't been maybe an influx of cases but we actually have a question here from the audience. Are you seeing new types of clauses being included in credit agreements to protect secured creditor rights in the event of a sub V?
I have not yet. I have not. I saw it when we were negotiating post-effective and Lunia specifically, but I have not seen any changes in normal financing facilities that speak exactly to this situation. And if you think about it, any $10 million facility now wouldn't even talk about it, since the statute even back when was 7.5 non-CUD. I don't know if Greg's seen other things or Jeff has, but I know I have not seen that yet.
I haven't seen anything either. I just wanted to cut in to just say, if you're on the East Coast and you want to do a sub 5 and you're not talking to Joe, then you're a fool. So so anyway, just want to throw that in there. I'm on the other side of the country, so I can say that. But anyway,
thanks for the endorsement, Greg. Really appreciate it.
No, appreciate that. This has been so much fun. This has been so great. I personally learned so much about Subchapter 5, and really appreciate you all being here, Gregory, Jeff, and Joe. Thank you again so much for your time. I hope this was useful. This will also be replayed in a couple weeks on our podcast. Thank you all so much for your time. This is so much fun.
Thanks so much, Mike.
thanks up to you.
And there you have it. I hope that was helpful in understanding what Chapter 5 is and why it was introduced. Also, what the maximum debt you can actually have, what that cap is in order to qualify for Subchapter 5, why it may make sense, why it may not make sense as an instrument in order to recap your debt. Thanks for listening. Again, this is brought to you by Manufactured. We try to produce helpful content. We really hope that this content is helpful in order for you to achieve your business goals from an operations perspective. Not only do we produce content, we also throw events. We throw events around the country. Check us out at manufactured.com/events. Our goal is to help bring together the consumer ecosystem through events, through community, through content. We really hope you enjoy. What Manufactured does is we're an inventory success platform for consumer brands. We help finance inventory. We can help reduce COGS. And we also can help distribute inventory across new sales channels. If you do want to learn more, check out mfd.com. Thank you.